I don't know if you pro-aborts actually understand what it means to codify something into law. Do you believe if the federal government codifies Roe v. Wade into law that it's magically going to restore everybody's constitutional right to abortion?
First of all, it's pro-choice, not pro-abortion. Someone can decide they're against having an abortion for themselves without supporting the government stripping the people of the right to consent, the right to bodily autonomy, and the right to privacy, precluding the government from reviewing the decisions made between an individual and their doctor. As for codification, it's unclear to me whether you're confused about what codification of law means, or you need a primer on how a bill becomes law.
States can always pass legislation that is more prohibitive or more restrictive than a federal law.
But that is just factually, constitutionally wrong. Article 6, Paragraph 2 of the United States Constitution states, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." Issues of federal supremacy go back all the way to Marbury v. Madison. However, perhaps the most instructive case on this issue would be Cooper v. Aaron. In a joint opinion authored by all 9 justices, the only instance of that occurring on record, they held, amongst other things, that federal law can neither be nullified openly and directly by state legislatures or state executives or judicial officers, nor nullified indirectly by them through evasive schemes for segregation. In other words, Arkansas attempting to pass a law contradicting Brown v. Board of Ed was preempted by federal law. So if the Constitution is the supreme law of the land, and the Constitution says federal law is also the supreme law of the land, so does that mean Congress can pass a law that preempts state law? Indeed it does. In Altria Group v. Good, the Supreme Court stated that Article 6, Clause 2 of the Constitution provides that the laws of the United States shall be the supreme law of the land. Anything in the Constitution or the laws of any state to the contrary notwithstanding, consistent with that command, we have long recognized that state laws that conflict with federal law are without effect. Codifying Roe in federal law would render state laws banning abortion without effect. As long as Congress was clear that federal law expressly preempted state law or provided a field preemption whereby the regulations introduced by the law so thoroughly covered the field of topic that no room remained for state law to govern, federal law, not state law, would govern. And then the only question would be whether the law itself was constitutional, not whether it had supremacy over state laws.